What I had thought to do this afternoon was to examine briefly a few programs, policies, and issues that have been in place since this administration took office, to see to what extent that last hope that I expressed was realized, and to what extent not. And I had thought to start with the positive, the instances in which wishes were fulfilled, and then proceed to the instances in which they were not. As I say, that was before the announcement this morning that the administration intends to bring to this country several detainees, including Khalid Sheikh Mohammed and Ramzi bin al-Shibh, the architect and principal operative, respectively, in carrying out the September 11, 2001 attacks on this country, and to try them in a civilian court. In fact, in the court in which I used to sit, the U.S. District Court for the Southern District of New York, and to bring as well another group headed by a man named Nashiri, and to try them in a military commission stateside at a place yet undisclosed. I still plan to follow, to a certain extent, the format that I had intended to follow, and to start with some positive news. But obviously, I want to deal with some extent with the decision to bring these detainees here. A decision that I consider to be not only unwise, but in fact based on a refusal to face the fact that what we are involved with here is a war with people who follow a religiously based ideology that calls on them to kill us, and to return instead to the mindset that prevailed before September 11, 2001, that acts like the First World Trade Center bombing, the bombing of our embassies in East Africa, and other such acts can and should be treated as conventional crimes and tried in conventional courts. But first, the good news that I promised you. The first category has to do with intelligence gathering. Although there was actually an incipient move in Congress to repeal the authorities that were put in place under the Foreign Intelligence Surveillance Act amendments that were passed in 2008, that appears to have been beaten back. And intelligence gathering authorities have remained in place. To what extent they're being used and how is something I obviously can't speak to now, because I'm not privy to that, and even if I were, considerations of security would not permit me that to be discussed in a forum like this. However, I can tell you, based on a report from somebody who was there, that at a meeting between representatives of the Department of Homeland Security and foreign security officials to discuss how the current procedure for tracing money transfers through what is known as the SWIFT system, which monitors international money transfers, was described to those foreign officials, their reaction was that the procedure was the same as the one that had been in place under the prior administration. The U.S. Homeland Security official who was present agreed and pointed out that this was continuity that you can believe in. Now, that is actually reassuring for two reasons. The first, of course, is the continuity, that the program is still working. And the second is that there is somebody at Homeland Security who has a sense of humor. The same appears to be true, at least for the moment, as to procedures that were in place, that we at the department put in place to allow the FBI intelligence gathering to continue and to be subsumed into its already existing crime-solving functions. We put those procedures into effect in December 2008, well after well over a year of consideration and review, and despite pressures to roll back those procedures, they have been left in place, at least for the moment, and the Department of Justice has indicated that it intends to allow them to work for a reasonable time before making any changes. All in all, an encouraging, if not surprising, conclusion. And finally, the administration has said that it will continue to recognize the state secrets privilege when litigation threatens to disclose national security information, and to bring such litigation to an end, even when the government is not a party to it. The administration professes to have a somewhat narrower view of that privilege than we did, but nonetheless, it's in place. However, when it comes to dealing with detainees and with those in our own government who've been involved in intelligence gathering, and of course, when it comes to the events of today, I think the record is less encouraging. Beginning with the detention and apprehension of prisoners on the battlefield, proceeding through obtaining intelligence from those who may be in possession of it, prosecuting those who can be charged with war crimes, and detaining those who may not be chargeable with war crimes, but who nonetheless were captured while engaged in combat with U.S. and Allied troops who may very well target civilians, who do not wear uniforms or follow any recognized chain of command, and who therefore can be detained at a minimum as unlawful combatants and obviously are much too dangerous to release. Here again, the plan seems to be to abandon the view that we are involved in a war and to apply procedures appropriate to a war, which is the view that was adopted after September 11, and to return instead to a September 10, 2001 criminal justice model of the sort that prevailed in the 90s, when we had the first World Trade Center bombing in 1993, the bombing of our armed forces facility at Khobar Towers in Saudi Arabia, the attack on the USS Cole that killed 17 sailors, the attempt to attack another destroyer called the Sullivan that would have succeeded but for the fact that the boat carrying the explosives sank, both of those, the successful one and the unsuccessful one, having been orchestrated by Mr. Nashiri. The bombing of our embassies in East Africa, in Kenya and Tanzania, and eventually the attack on September 11, 2001 that killed almost 3,000 people. All of that seems to have followed sweeping proclamations, that is, that change of attitude, announced in January 2009 that implicitly, at least, suggested that the prior administration had sanctioned torture and had been bent on detaining detainees at Guantanamo without proper treatment or access to legal proceedings. The pronouncements were that we would abandon harsh interrogation techniques, which were loosely characterized as torture, and would close the detention facility at Guantanamo within a year. What's followed has seemed in many instances to be a system in which policy is fashioned to fit antecedent rhetoric rather than being thought out in advance with arguments then formulated in support of it. With respect to interrogations carried on in the past, because of the at least implicit suggestion that the prior administration had sanctioned torture, the Department of Justice pressed the argument, successfully, that previously classified memoranda that described the limits of coercive questioning that trained CIA personnel could engage in should be revealed, along with the legal reasoning underlying how those limits are set, should be disclosed, with the result that our enemies are now to be made aware, or are now aware, of precisely the legal and factual limits of how they can be treated if captured, and to train accordingly, as they did before, using the Army Field Manual, which described less coercive techniques that can be used by soldiers in the field and was generally available on the Internet. When he was a candidate, the President was quoted as saying that it would be absurd to contemplate that Miranda warnings to those captured on the battlefield would be given, but the armed forces have been directed to provide such warnings to those captured on the battlefield in Afghanistan. In addition, cases involving claims that CIA personnel acted unlawfully in the course of interrogating prisoners, which were reviewed by career prosecutors in the Justice Department and found insufficient to justify prosecution, except for one case against a contractor that was in fact prosecuted, and the subjects of those investigations were so notified at the time, are now being reviewed again, even though the determinations in those cases were fact-specific. There is no claim that new facts have been developed, and from all reports, the Attorney General who directed that that second review take place did not himself read the prosecutive memoranda that were drafted after the first review and that explained why the decision not to prosecute was made. And of course, there has been this morning's disclosure that the government intends to bring to the United States several defendants charged with planning and participating in the September 11, 2001 attack for trial in the U.S. District Court in New York, including the self-proclaimed mastermind of that attack, Khalid Sheikh Mohammed, as well as a principal organizer of the operation, Ramzi bin al-Shib. In addition, as I said, another detainee named Nashiri and others associated with him, I believe 3 or 4 others, are to be brought here and tried in military courts.